Hello, everyone, and welcome back to another episode of Future Contracts. Today, I'm very happy to be speaking to Nate Kostelnik. And Nate, I've been following you on LinkedIn for a while. We haven't actually met in real life, but we have been interacting on LinkedIn quite a lot. I think we're both interested in quite similar topics. So I'd love to hear more about you and your background and how you got into this space.
Yeah. First off, thanks Electra for having me on. I've enjoyed following you and as well. So I'm in Pittsburgh, Pennsylvania. I've been a lawyer for many years. Started off with litigation, eventually moved to IP and corporate and transactional work, and eventually got to kind of the commercial contracting space. So I'm in-house now with Oncology Nursing Society. We're a international nonprofit for oncology nursing professionals. So we have about 40,000 members active, and no 2 days are the same here. So keeps us busy.
Excellent. And there's a lot of talk about AI, and you write a lot about AI and the impact, good and bad, on the legal profession. Do you use AI in your own work at the moment?
I do, and it's getting to the point where I don't know when I don't use it. Personally and professionally, we're at the point now where whenever I sit down to do something, how can I use AI for this? It will help you get kind of the next step, maybe something you're not thinking about, and it's just super helpful. If you've never used it, dive in.
Yeah. That's a pretty kind of steep transition for in-house lawyers, I think. And when we look at other legal tech tools that have been on the market, none of them have had the immediate impact that we've seen with AI. Why do you think that is?
Well, I think lawyers are always kind of a cautious bunch, and so there are real concerns with the information you're sharing, confidentiality, privilege, and accuracy. There's still concerns that if it's not 100%, you're duplicating work and you're relying on output that you didn't do, and so you're not kind of doing your duty to ensure that the work product you have to stand behind is up to snuff. And so there's still, I think, a lot of concerns, valid concerns, and doubt, hesitation for people that want to dive in and say, yeah, this is neat, but it's not quite there yet. And so I think there's some reluctance for that perspective.
So you use AI on a daily basis. Can you give us some example of how you use it?
Contract review is one of the easiest ways, I think, to get started. Even if you're not relying on the finished output, and even if you're not looking to it to do your job, even just experimenting with it is kind of how I've gotten started and how I tend to use it, even as a checklist. So you have kind of a playbook of concepts I want to look for. I'll have AI do a first pass review to kind of give me a lay of the land, so to speak. And so then I know what I want to dive into next. So if it generates red lines, if it generates comments, that's great. But I'll probably always do that myself for now. But I do use it for that first pass review and a checklist to make sure, hey, am I missing anything? Is there anything that I'm not looking out for?
Yeah, I think I think contracts were designed for AI. If you were to design something for AI to disrupt, it would be contracts. They're just, patterns, repeatable patterns that AI is so perfect for. So I think that will be the space that gets disrupted the most first.
It's helpful because it can do so much work in such a short amount of time. And so if you prompt it well and correctly and give it the context for what you're looking for, it will read a 50-page MSA looking for the exact same thing you would be looking for if you manually reviewed it. And so it is instant feedback in a way that would take you hours. And so it can cut down even that kind of first pass level of work.
Yeah, it's pretty amazing. You've written about this recently, but At the moment, we're in the first wave of using AI to review contracts. And so there is still quite a deep level of human oversight. But do you think we'll get to a point where lawyers are kind of cheating the system and drafting for AI?
Maybe, maybe not. On the one hand, I think it's fun to experiment to learn how AI will review a contract, and one of the ways to do that is can I slip something past it? Can I draft something? I called it clever drafting. Can I create something that would not be caught by AI? I don't know if we'll ever get to that point as a effective, desirable, or practical solution, because I think AI, at least for now, is smarter than all of us, and it'll catch you. So, but I still think that's a useful exercise to go through to see how you would draft with a non-human reviewer in mind. Because on the one hand, you could do some, again, clever drafting and try to slip something through, or you can say, hey, look, I'm trying to build a collaborative relationship here with the counterparty. If I expect that they will use AI to review my contract, is there a way I can write it differently so that it will improve the review and make that review process go quicker?
Some of the more cynical people who might be listening to this may be inclined to say that we've always done that. So why would we not do that going forward? You know, hiding stuff in opaque language in a 20-line paragraph with very few commas and full stops is a way of trying to pull one over the other side. And part of the fun, in inverted commas, for the lawyer that's reviewing is to try and pick those out. So how is that going to change in a world of AI, if at all? I kind of think that it's inevitable that people are going to try and slip one through the net.
I think that's a great question. So I have two responses to that one. One, in thinking about how you might try and slip something by AI, the challenge that I keep coming back to, this is something I think anybody could try and test out, is try and draft a limitation of liability clause that AI wouldn't recognize as a limitation of liability clause, but which a judge looking at that contract 5 years from now would say, hey, this is a valid limitation of liability clause. I'm going to enforce it. I don't think you can thread that needle. I don't think we have the capacity to be that clever while still creating something that can be enforceable. So I still think there's a natural barrier there for our ability to draft cleverly and slip something past. But you're right. To the other point is that we've always, not we, but some people out there have always done this, right? And to a certain extent, that is the role of the drafter, is to kind of protect your client. And so, if you have a definition that maybe isn't as clear as it could be, but which creates an advantage for your customer, your client, people are still going to do that. And so, I think when we look at how we might think about, should we do that? Could we continue that with AI? I've talked about what I call drafting capital, which is, as you're drafting a contract, you're building trust with your counterparty. Ideally, you're building trust. You could also ruin that trust. And so if you slip in terms, if you intentionally, get too complex with your cross references, if you have heavy-handed terms, that may be great for you in the end. But when your counterparty sees that, every time they see one of those elements, they lose a little bit of trust in you as the drafter. And so not only are you going to get more red lines on those items, but they're going to scrutinize the rest of your contract more because they don't trust you. And so I always like the phrase, the more red lines you get, the more red lines you get. And it's the idea that, if you create a contract that is going to trigger somebody and cause them to distrust you, not only is that going to be one red line there, but it's going to carry through elsewhere. So I think we'll see that also with AI, because it just exploits that and magnifies it even more.
Yes. What happens in a world where humans almost never read the first pass of an agreement because it's all outsourced to the bots? So if you're using AI to draft an agreement based on your principles, and then you're sending that agreement to the other side, and they're reviewing it using AI based on their playbook of preferred positions, this red line ping pong ensues regardless of who's drafting and what's reviewing. But you don't get that initial emotional response that we're used to getting, being from a generation where you do review manually, where you could be reading the first pass of a contract and actually get angry. I've got angry before, just read like, why would you do this to me and put this,
Yeah.
I can't, my brain doesn't want to read this horrendous language. Or why did you try and plant this bomb in here? I've caught it now. Now I don't trust anything. I'm going to scrutinize every line of this
Yeah.
agreement. That's what happens.
Yeah, I think that's a really good point. And, with AI taking over more of that role, I think there's kind of a sense of shame that we sometimes feel with sending too many red lines over. You always say in your cover email, hey, sorry for all the red, but, this is what I was trying to do. But I think you lose some of that when you can kind of pass all those red lines off and say, hey, this is something that our AI generated. This is just our playbook. So you kind of lose that human element and that human responsibility, and even that sense of, like I said, shame or maybe embarrassment that, hey, am I redlining too much?
Yeah.
Because the AI doesn't care. So
Yeah. But, are we going to get to a position where it's like, sorry, the computer says no? This is what our AI says based on our preferences that are driven by policy at organizational level. Are we going to be using AI to absolve ourselves of responsibility for the horrendousness of our markup?
yeah, we still get back to there's going to be a human that's going to create the playbook. So you have to go through that process and tell the AI what to look for. And so, in a way, the volume of red lines that your AI generates are a reflection of what you told it to look for. So you'll still have that element. Um, I guess the other direction you could go is, standards. And I know you're a fan of standards. And I love what we're doing with one NDA and one and everything, because I think that is a different path forward. It's not the back and forth red lines, whether it's human or AI. It's can we cut that part of the process out and start from a place where we don't even want to engage in that, or we don't need to do it as substantially as we might otherwise do, the back and forth red line. So I think it's starting on a much leveler playing field.
What do you think the future of standards is in a world of AI? Just to expand on that a bit more.
I part of me does worry, because I think there's an allure for what AI can do, and it's easy to jump in and see how AI will accelerate. I can put in my playbook, and I can have the red lines reflect what I want my playbook to be. And so it's a little more user centric and less collaborative. I know the counterpoint is obviously, you can have AI identify points of disagreement faster, and you can still collaborate from there. Will everybody do that? I don't know. And so that's kind of the one cynical perspective, is that if everybody starts adopting their own AIs and starts doing it, does that kind of lead us away from an area where a world where standards are seen as a viable alternative or viable solution? On the other hand, standards are great. And I think once you kind of dig into them and you see what they're designed to do, and it's not just my standard template, it's something I didn't even draft. It's a collaborative effort to reach consensus. And the goal is not to engage in that back and forth red line. And there's a much better way to think about how we negotiate the contracts. And one of those is standard. So my kind of off the cuff idea is that, maybe the next 3 to 5 years, there's kind of the all in with AI. We see that growing and growing. And then at some point, maybe a few people reel that back and say, hey, did this really get us where we want to be? Maybe standards are a better starting point. So
Yeah,
that's
I
my
want to agree.
optimistic take.
I want to agree because I think that if you can get a bunch of AI agents to argue between themselves, then arguably there is no labor intensive human effort that's required to negotiate a contract. And that's the thing that motivated people to, in some instances, go to quite long lengths to adopt one NDA and to get it through their governance, because they just do not want to negotiate NDAs anymore. It's absolutely depressing to do that, and they just can't. They just don't want it. So they'll go they'll go to the lengths that are required to get a standard adopted. So then if you're to outsource that labor to an AI agent, then is there any motivation left? And I think the motivation will come when we, to your point, go to the extreme drafting, which I know that you also talk about, this extreme drafting lengths where you think, well, if there's no human reviewing it on the other side, and I can just fall back on the fact that I'm using AI to draft and redline this agreement, that I'm just going to just put everything in there. And I'm going to have a 700-page agreement, God forbid, but I'm going to have a 700-page agreement because I'm not going to annoy anyone on the other side because it's just bots doing it.
Yep.
So we may get to the point where that's happening and agreements are being inflated and bloated and bloated and bloated to the point where they're becoming so convoluted that even the AI is getting confused and escalating all the time to the human, at which point we've now exacerbated the contract problem. And then people will start to roll it back and go, hold on, why did we do this? Should we just adopt a standard and be done with it? And then there's no negotiation allowed.
Yep. And I think it goes back to another point we talked about too, is, if you standards can serve the idea of drafting capital. So everybody always has their story where if you get an NDA and negotiating the NDA, takes a month and it's contentious and it's back and forth, that's not a good sign for the ensuing negotiation over the substantive agreement. Yeah. And the flip side also works too. So if you are able to start an NDA from one NDA or a standard NDA, that positions you much better in terms of having drafting capital, so that when the other side sees your template agreement, they're already going to be starting, hopefully, from a better sense of fairness and expectation that, hey, they had a fair NDA to start with. There's a better chance that this agreement is going to be fair as well. So I'm more willing to be collaborative too. Maybe I'm not going to redline as much because I have a better sense of trust that they've built up from using that standard.
Mm-hmm. And just to elaborate a little bit more on standards before I move on to the next topic. But when we released one NDA, and other standards have been released as well, not just in the commercial contracts world, but just across the board in various verticals, often it was hard to get people to adopt them. And it's because they wanted to push their own agenda, or because they saw a standard as diminishing their commercial position, because then they have no chance of getting exactly what they want. And so why would they start from a starting point that was kind of less advantageous to them from the outset? So there was that. So I think to an extent, the problem wasn't painful enough for them to go to the lengths to adopt the NDA. And where it was painful, like in the instance of an ISDA, where they were spending hundreds and hundreds of thousands on a law firm to give them an opinion on a document that was identical to the one they signed yesterday, that forced them to enter into this world of, well, standards are the norm. So perhaps AI will exacerbate the problem of contracting to the extent that people will now feel the pain so much that they'll revert to standards. But we shall see.
And I think that's a great point. I think the other point about standards, we talked a little bit about playbooking as well, is you can use standards to help guide your playbook creation. And so if AI redlining is a reflection of the playbook that you put in, on the one hand, you can put in very heavy-handed, one-sided clauses that it'll redline, and the other side's probably going to redline back and forth. And do you really get anywhere with that? Or do you create a playbook and consult with and refer to standards that are designed to be more mutual, fairer, less one-sided. And so that is maybe a shortcut to creating more collaborative negotiations, even if you don't rely on or sign on the standard. You still use your playbook, AI powered, but based on standard contract for the playbook creation.
Yes. Yeah, and talking of playbooks, I think that's an area that's about to become mainstream. So back in the day, when you talk to people about playbooks, it was just something that they always aspired to have. So playbook is a document that outlines your negotiation positions and your preferred positions within a negotiation, and maybe you had some sample language that you like to use if the other side proposes different language. But very, very few legal teams actually documented that on paper. It was mostly in people's brains. People relied on their instincts. You might have one legal team and they all just applied their own preferences, and there was never actually a conversation about, well, what's their position as an organization? But in a world of AI, I think wave one of AI adoption will be the realization that a playbook is the magic tool that unlocks the power of AI. So how do you think people will approach that opportunity? So how do you think they'll start drafting their playbooks? Will they be quite aggressive with the rules once they realize that you can just draft a rule and then the AI will do the heavy lifting? Or do you think they'll be more minimalist to begin with?
I hope it's maybe not minimalist, but much more thoughtful. And it's not adding in every, AI can do a 700 item playbook. But do you need that, or do you want that? Is it worth you going through the creation of that when you might be able to sit down and identify, hey, here are the 10 or 12 key issues we really care about. And in creating the playbook, you can go through that thoughtful process and identify what you really care about and craft clauses in a way that you can say, hey, this is likely to be accepted. This is likely to get us to agreement faster. Here's our well-reasoned and well-thought-out position for why we're including this in our playbook. So I think that's a really powerful way of getting started. And also, the benefit of the playbook is what isn't in the playbook. And so when you go through that process of identifying what you want in there, you're also saying stuff that I don't care about, stuff that isn't going to be something I'm going to redline, something that I don't want to get hung up on negotiating, and stuff that shouldn't slow down a deal. And so when you make that decision in creating your playbook, that's also reflected every time your AI reviews a contract and says, we don't care about the severability clause or whatever you have as an example. You're already getting the benefit of having gone through that playbook creation process.
Yeah, I think that's a really important point, and it's something that is kind of valid even pre-AI. So, what are your negotiation positions? And having just the act of having a playbook, whether AI or not, avoids the situation of you just on a Monday you're just redlining this because you're full of energy from the weekend. And on a Friday, you're like, can't be bothered. I'm not going to redline this today. Right. So you create that consistency across the board. But it might be quite tempting because when you're creating a manual playbook, just in an Excel spreadsheet, for example, you might feel sorry for your future self having to follow a playbook with 70 different points. But if it's an AI playbook, then you might be tempted to add 70 line items because the AI is going to be doing the heavy lifting. But I think this could boil down to the way that lawyers view themselves and their roles within an organization. Because your job isn't to catch every possible risk, your job is to facilitate the deal. So now that you're using AI, you almost need to be more thoughtful because the other side is also going to be using AI. And so you don't want to set the scene. What do you think of that? Is that how you approach it?
Yeah, I mean, I thought you had a really good point there with, I can sit down and put 70 items in my playbook and it's okay that the AI is going to implement that and review for that. But that also means there's a chance that it'll go to the other side. Their AI will reject all of them. It'll come back to me. And now I have to manually review all 70 of those and say, well, do I care about this one? Yes or no? Do I care about this one? And so now it kind of creates more work for me. When if I would have been a little more intentional at the outset, I could have avoided that.
Yeah. Just on the same kind of note, do you think there's a risk that reviewers will become overly reliant on the AI to the point where when they have to exercise their judgment, they just won't have the motivation to do it because they're no longer, they don't want to do it? Like, I feel like that's kind of happening to me now. If I need to cook a meal, I'm just going to go to ChatGPT to tell me exactly what I can do with the ingredients in my fridge because I can't be bothered to think about it. And now I'm like, am I losing my creative flair when it comes to cooking because I'm outsourcing it to GPT?
Yeah, I think that's a great question and a real risk. I think one of the interesting things, I started in litigation before I moved to transactional work. So, and one of the observations I had that I got from a mentor who did the same switch is he said, if you make a mistake in litigation, the other side sees it and will call it out within 30 days. They have to file something in response. So if you made a mistake and it's going to be front and center immediately. Transactional work, you may not know for 10, 20, 30 years if you know it all. And so I think when we hear about I think we're up to like 150 cases where lawyers have gotten in trouble for using hallucinated citations. We haven't really heard anything yet from the transactional side because that stuff hasn't bubbled up yet. But if we assume that if we know that it's happening in litigation, I think we have to assume it's happening every day as well with contract review, where exactly what you say, people are being overly reliant on AI. They're not maybe it's not first pass review, maybe it's only pass review, and you're not double checking it. And so will anything ever come out of that? Will those issues bubble up? Will we see any bad consequences? I don't know, but it's definitely not as immediate as the litigation context. So we don't really have a baseline to compare it, but I think we just have to assume it's happening.
How would that manifest? So in what way? Would it be like a badly drafted clause or something that makes no sense that later results in a dispute? And then you're like, oh no, sorry, the AI did it.
Yeah, I think it could be, you could think about maybe payment terms. One of the scenarios that's been on my head recently is if you say customer has to pay an invoice in 30 days, and in the 30, the 0 is in white font. So the AI may see that as 30 days, but a human reviewer, and if you have that contract signed, it's going to appear as 3 days. And so something like that, if you rely on the AI, the AI is going to say that's okay, but in I don't know, maybe a month or so, 3 days, once you get an invoice, that's when it'll surface. So that's one example. Obviously, limitation of liability. If there's maybe a carve out, which I think is where we sometimes see inconsistent ways of drafting exceptions and carve outs to limitations of liability. Sometimes they're embedded in the clause itself. Sometimes they're a separate paragraph. And so I think there's a possibility there that the AI may not implement your playbook the way you want it, or there may be an exception or carve out that I didn't intend it to be written that way. That's not what I would have done, but here it is. So I think that is something that hopefully doesn't come about in a dispute. But that 5-10 years down the line, that's a possibility.
Do you think that judges will start using AI to interpret contracts as well? I believe that's already happening a little bit in the US. But do you think that the judicial system needs to change as well? Because if we can assume safely that everyone's using AI to review and draft contracts, then surely the judges need to start deploying AI to interpret those contracts, both from how a human is perceiving them, but also how the AI is perceiving them. And where's the line drawn in terms of the meeting of the minds?
Yeah, on the one hand, I think everybody would want and would benefit from you could have a court that would review using AI because it's going to give a ruling much faster. That's what the parties want. They don't want to sit around and wait for a court to look at thousands of pages of exhibits and evidence to come to their ruling. The AI can assist them in combing through that and getting an answer much quicker. I think with the resistance that a lot of us have, especially in the transactional space, about entrusting AI to kind of take over contract review, people will say it's not quite there yet. It's still not accurate. It's still not finding the clauses I wanted to. So I think with that resistance and that hesitation, I think we'll see the same distrust for AI being used too much by courts. I think people still want that human element of judgment, which I think is still what maybe separates us from the AI. And so I think people will still expect that judgment from a court or a judge, obviously, to still provide kind of the ultimate decision and not entrust that entirely to AI.
Yeah, definitely. I do see a world in which the judges are augmenting their judgment with AI, so that they can also understand how the parties may have missed something, or if someone's saying, well, that, my AI interpreted that as 30 days because of the white font, then you would have to use AI to verify that that would be the case, and then that's a more defensible position. And there may be lines drawn around kind of what's appropriate to delegate to the AI versus where you need to apply your judgment and taste to assess what the agreement's saying. I wonder whether there'll be governance or rules that are set around that as well in the future.
Yeah, because you still want to have, once you've used AI, it's mind-blowing how productive and helpful it can be. And so while you still want to reserve some human element of judgment to the courts or the lawyers or whatnot, on the other hand, you want to say, hey, if you're not using AI, are you missing something, or are you doing as good of a job as you can be doing? There was a great video that I know I saw it through your feed. He did like a 10-minute video of the girl who wanted to be a lawyer, and her father said lawyers don't exist anymore. And he did the whole, I hope you link that, because that was a great video, movie that talks about, if you're not using AI, are we going to look at you with doubt? And I think that's going to accelerate.
I think so too. I've made this point before, maybe on this podcast with another guest, but if an accountant told you now that they do your accounts with an abacus or pen and paper or a calculator or even Excel, you might think to yourself, why on earth are you not using a tool that is fit for purpose, that was designed for this? You're being inefficient. And I also don't trust that you've done my accounts properly because you're not using state-of-the-art technology. I don't see that there is any way around it. People are going to expect us to use AI tools to do our jobs. Reviewing contracts is the perfect combination of stressful and boring. And when I used to review contracts for a living all day, sometimes you've got 5 contracts to review in one day. It's exhausting, isn't it? Because you're reviewing the same things again and again and again and again, and they all say the same things in different words, but the substance is the same, which is where I kind of got the whole idea for one NDA.
Yeah.
Like, what are we doing? This is insane. So to be able to delegate that to something that is cleverer than you, because it's got all the knowledge, is amazing. And you're going to do it because you don't want to be doing that kind of work day in, day out. It might be quite fun when you're a junior and you're learning,
yeah,
and you're picking up stuff, and you get that buzz in your brain of, oh, I picked that up. I'm so clever. But then that quickly runs out. That excitement for you picking something up quickly runs out. And then the thing that I think people do still get a buzz out of, even when they're very senior when it comes to contracts, is crafting quite a complex process or concept that could be quite vague and difficult to understand, and drafting that and putting it together. That feels like a form of art, which the AI will help with, but you're going to have to tell it what you want. So you're still going to have to learn. There's other skills that you're going to have to develop the fun part of the job doesn't entirely go away along with the drudgery part that you don't want to be doing. The fun part still exists, but you kind of have to pivot your skill set into something that's more AI ready.
Yeah, I think that's a great point, and you brought up a concept that I really like too, and I think about a lot is kind of this idea of the art of craftsmanship. And I know Preston has talked about this too, and it's the idea that right now I think we do take a certain joy in crafting a well-designed clause that is going to protect us in a very remote or unlikely scenario. And 10 years down the line, that contract's going to appear before a judge and they're going to rule in our favor. And they're going to say, I see what that person was thinking when they drafted this. This is fantastic. And I think we still do draft a little bit with that idea that someone, a judge or someone else 10 years down the line is going to appreciate that level of craftsmanship and that nuance that we thought about right now that we want to put in. And I think AI threatens that a little bit. We don't feel like it provides the level of craftsmanship that we do, and only lawyers and contract professionals can have that level of craftsmanship. And so I think that's one of the reasons why we see some resistance to delegating too much of that to AI.
Yeah. And I think the counter to that is that you're not delegating it to AI as such. You're learning how to talk to the AI to get the output that you need.
Yeah.
Plus, you can get someone, the AI, to pressure test what you've just created in a way that you won't be able to get if it's just you and one colleague in an office. If you're in an in-house environment where you don't have a huge team. It's different if you're in a law firm. You can run it past the partner and they kind of give it the sign, the seal of approval, and you're happy with that. Yep. But if you're under pressure in an in-house team and you don't have that infrastructure of other legal professionals who are fully focused on just what does this clause look like, it's an additional layer of support for you beyond just helping you craft. It can also challenge you.
Yeah. And that challenge is the benefit again with AI is that it can challenge you with instant feedback. And so you don't have to draft a clause and have it go out into the market and, wait 30, 60, 90 days to see all the various red lines you get and the responses to that clause. You can almost do that at scale immediately with AI. And for example, anticipate 5 red lines that I would get to this clause, anticipate 5 reasons why a court may not enforce this. And you can get that instantly. And so then you can draft in real time kind of the responses and recraft those clauses.
Yeah. So Nate, it's 2030. The year is 2030. Everyone's using AI. What's the ideal AI contract review workflow in your opinion?
I think one thing that I think a lot of people will want to see and will expect is 100% accuracy. I don't think that, if it's 85% or 90% now, I think a lot of people look at that and say, if it's not 100%, it doesn't really matter because now I still have to go back and review it. And so I think a lot of people see that level of trust and can rely that it's 100% accurate with whatever it's tasked to do. It's still kind of reliant on your playbook. And so if you tell it to look at 8 issues and it nails those 8 issues with 100% accuracy, you can't say, hey, you missed the 9th issue over here. Well, you didn't tell it to look for that. So I still think you will see people expecting that kind of 100% accuracy. I think the other aspect that let me pause for a second. I actually wrote this down. Is a little bit more with leveraging that instant feedback loop. And so one of the things that I would like is as I'm drafting, it would be great to know if the clause I'm drafting is it market or is it not? Am I veering too far off course? And so you could see if there's like a little needle that would say, hey, you're drafting something that's not going to be accepted. go in this direction. And so it kind of steers you to something that is going to be enforceable and also something that, gets you where you want to be. So I like that element of it being AI being much more collaborative with us as we work through some of those issues and help draft. And then I think the last element, and I think we'll see this with some of the agents as they come out, is, when we get contracts these days, it's a Word document with no context. Our internal team just forwards something in. We don't know who the counterparty is. We don't know the deal size. We don't know any of the other issues. Maybe we have an intake form, but usually it's just review this Word document with no context. And I think that AI will help bridge that gap and extract some of the context for us and embed it in the review process. So maybe it's not so much the manual email back and forth, hop on a call. While productive and helpful and necessary, I think AI can step in to some of that process and help us get to the review itself much quicker.
Yeah, that sounds great. And I love the idea of AI surfacing insights that allows you to be more collaborative. Because if, for example, the AI collated information about how people are responding to your drafts or your red lines, and then it told you, look, in 99% of instances, this non-solicit in this type of agreement is rejected, then you'd think twice, because your objective as a lawyer isn't just to kind of score as many points as possible for your team or to annihilate risk entirely. It's to get a deal done. Yep. And I think that pressure is also going to come from above as well. Stop being a bottleneck. You've got the tools now. If you're using the tools and you're still a bottleneck, then the tools are not the problem, and the manual nature of your role is not the problem. It's your mindset that's the problem. And I think we're going to get that pressure much more. But it's amazing if you can have a co-pilot that's supporting you, not just with the automation of the work that you would otherwise do manually, but also by surfacing insights that are gonna create better contracts. Because ultimately, that's what this should be about. This shouldn't just be about automating stuff that people can't be bothered to do. It should be about solving this problem, which is contracts. I mean, I probably shouldn't be saying this being on a vendor side that sells AI contract review software, but the very fact that we need to deploy AI to review contracts makes you question the whole construct of a contract and whether it's appropriate in the first place. The whole purpose of a contract is for us to achieve that meeting of the minds. So if we're not able to do that by simply reading a document or having a conversation with the other side, because we've got to the point where our documents are so convoluted, then we do really need to take a step back and think about what we're doing and how we're trying to solve that problem.
And I think that's exactly where standards can step in. And if we're looking for a way to, I think you said, kind of question what we're doing, if you have a standard that, as you're drafting something, the AI would say, hey, look, you're coming pretty close. Why don't you just use this standard contract? Why don't you just use one NDA or one SAS or whatnot, something like that? It gets you to that more collaborative approach as a co-pilot. It suggests, the war games from the movie is the best way to play is not to play. And so is it not playing with red lines? Maybe we should just use a standard. So I think there's that opportunity away from overly back and forth redlining to something like a standard.
Yeah, that's awesome. And so I suppose one thing that strikes me from your vision is the fact that the lawyer is still in the driving seat in this new world. Your ambition is not just to completely outsource contract review to a bot. It's you want to remain in the driving seat, but you want the support and the insights that you otherwise don't get.
Yeah, I think for the foreseeable future, we still recognize that AI is not 100% there yet. I mean, if you've used it to review a contract and it catches something that you didn't think about or the alternative, I think people will still say, I need to be involved. It's not quite where I want it to be. So I still think for a while, people will definitely say, I want to be involved. I can't outsource it entirely. But on the flip side, I don't know if it's entirely our decision to make. You'll see about once a week, someone will post on LinkedIn or Twitter X. And I know Preston commented from someone who did just this and said, Claude is our new in-house counsel, and not for everything, but he's still using it, using outside counsel to double check it. But that decision of whether to go to outside counsel first or to run it through Claude wasn't made by the lawyer. It was made by the business team or the user. And even though he had it checked by outside counsel, the decision was something that he made, and I think we'll see that decision a lot more. So whether and to what extent we get replaced in the process, I don't think is always up to us.
Yeah, totally agree. And that's I listened to that whole podcast, and it was fascinating, by the way, so recommend. But I wonder whether we will get to the point where other teams, just talking about in-house specifically, because in that example, that person was saying that they would normally use outside counsel, but they'd get a massive bill and it would take them days, if not weeks, to get back to them. Whereas now he's just replaced all his lawyers with lawyers that are happy to just verify AI output rather than insist on giving them a full-blown opinion. Yep. So what he did is he ran this complex problem that he had through Claude. He got an output, and then he asked his outside counsel to verify that whether that was correct. Now, obviously, that's not good for the outside counsel who's used to billing billable hours and charging whatever they want, because you have this discrepancy between their knowledge and that of the client, who's kind of less sophisticated from a legal aspect. So the law firm can say whatever they want. They can say, this is actually super complicated and I had to decipher it before I gave you an opinion that you can rely on. Now, all of that veil is going to be removed with AI. So I think the law firms should really be thinking about their position and how they're going to make up for all the billable hours that they are about to lose. But to your point, I think that the business teams will also look to their in-house teams. And if their in-house teams are bottlenecks, they're going to try and find ways around it. So a CEO that's, in the middle of a deal that he's desperate to get through because it's very important to their business, you'd hope that they have in-house counsel that fully appreciate that and are going to support them and take risks as needed. But if the legal team's a bottleneck, then of course they're going to turn to AI. And then they're going to use that as leverage against their in-house team and go, hold on, Claude just said this. Why are you taking 5 days and sitting on this? The answer seems to be simple to me. So, I think there's more than one ways that AI is going to disrupt not just the way we work and the operational side of things and deploying AI to review our contracts, but also the expectations that the business has of us on the basis that they're able to understand what we do much more now. So they can use AI to tell them how complicated it is. And now you can't hide.
Yeah, exactly. And to your other point before about law firms, I think it's a great opportunity for them as well, because now they can, scale and do more work. If they have a custom playbook, they have 5 similar clients, they can now review all of their agreements faster for all of those clients and serve more clients faster. So I think that AI does, it's a great opportunity, especially for the smaller solo and boutique firms to really leverage what they're able to do. Totally. Without maybe a loss of the billable hour. So
absolutely. I think that there will be a huge surge in boutiques and freelance lawyers and legal consultancies and ALSPs that are not bound by this partnership structure, which is binding these law firms to specific commercial models that don't lend themselves to the extensive use of AI. And you're seeing all these law firms going, I'm using this latest AI tech. But are you? And where's the benefit to the client? Because I'm not seeing it. I'm not seeing the disruption in your commercial model, because that is the only way. If you're really using AI, then that's really what I'm gonna want to see.
Yeah.
Everyone's gonna want to see that, and we're not necessarily seeing that yet. So I think the boutiques that are not bound by this legacy or by this partnership model and understand that the billable hour is about to get massively disrupted, they're the ones that are going to be first with innovative commercial models that will take the work away from big law. It's inevitable.
Yeah, it's too entrenched, I think, to have significant disruption. I think it'll find a way to move forward, but it's the same idea: is that that structure does need to be maintained somehow, and they're going to fight to keep it.
Yeah. Nate, it's been an absolute pleasure to speak to you today. I've been just reading everything that you've written, just consuming it, because and every time I read something, I'm just nodding away. So we're totally
I feel the same way about your newsletter. So
excellent. Thanks for being here today and for sharing your insights.
Thank
and
you.
to everyone who listened to this episode, thanks for being here, and stay tuned for the next one coming soon.
Thank you.